Good afternoon, everybody. I'm Fay Collinson, barrister at King's Chambers. Thanks very much for joining me today. I'm going to be speaking, as the slides say, on attorneys and unauthorised transfers. By way of housekeeping, just to explain that Sarah's unfortunately unable to attend today. One of her children, I think, has gone and broken a bone at school. So regrettably, she's had to go and attend to that. So it's just going to be me, I'm afraid. What Sarah's going to do, she's going to be recording her session, which was to deal with trustees and self-dealing. And so once she's had the opportunity to do that, then we'll send that out. I won't be offended if any of you, excuse me, just wanted to attend to listen to her session. So if the numbers do dramatically drop now, then I won't be offended. But I hope some of you will stay and join me for talking about attorneys and unauthorised transfers. Just before I get going, there's my email address. Do feel free to get in touch with me after the seminar if you've got any questions about anything arises from the seminar, or if you've got any matters that you need some assistance on. It's always quite difficult to answer the questions on the chat whilst I'm doing this. I do try to, but what I tend to do afterwards is download the chat. And if I can see any questions, I'll try to respond to people via email afterwards. So I'll do my best. There are the email addresses of my two clerks, Evase and Brandon. So as always, their remote door is always open. So do feel free to get in touch. For those of you who are new to one of our seminars, I am a barrister who specialises in property and affairs court of protection, property and wills, trust and probate. Today, my session is going to very much focus on the property and affairs side of matters, although it does touch upon issues of property. So I hope that you'll find it helpful. So, oh, that's not supposed to happen. Don't save, right. So last time I had a seminar, some of you who may have joined that, there's always a mishap with one of my seminars. Last time, my husband had walked in the house and wore his AirPods, and then God knows how it connected to my Mac, and he started talking. You couldn't hear me. So, so hopefully nothing further will happen as we speak about the case of Chandler and Lombardi, which is a decision of Jason Beer QC, sitting as a judge of the High Court. It's a decision that was handed down earlier this year, but it went to a trial in, I think, November of last year. So just to start off with the facts, I've been quite detailed on the slides for you because I know that they can be quite helpful to have that point of reference. And I always send the slides out after the seminar. So it was a claim brought by a Mr. Chandler on behalf of his mother. When the proceedings were issued, she lacked capacity, so required a litigation friend. And during the course of the proceedings, she passed away. So he then adopted the role of executor and stepped into the estate's shoes for the purpose of the litigation. The defendant was Mrs. Chandler's daughter and also the claimant's sister. So the dispute concerned family members. Just by way of testamentary background, Mrs. Chandler had a will from 1993 in which she gave her property to her 4 children in equal shares, albeit there was a life interest to her husband, who, as I'll come on to in a moment, passed away. What happens is around about 2016, Mrs. Chandler visits solicitors. And while she visits those solicitors, she has instructions for them to prepare her lasting powers of attorney for both her financial affairs and her health and welfare. And as far as I can glean from the judgment, at this time, there don't appear to be any concerns about her capacity. And so she appears to have also given instructions to the solicitors to orchestrate transfer of half her interest in the property to her daughter, the defendant. It looks like the solicitors dealt with the lasting power of attorneys, but in the judgment, it says that they refused or declined to act in the property transfer. And in the judgment, there is reference to one of the interfirm emails where one of the solicitors is of the opinion that this matter may come back to bite us regarding the client's intention of transferring her property to her daughter. So clearly they saw a couple of red flags arising, which I'm sure many of you would also identify. So the LPAs were executed. They were registered subsequently in the November 2016. And upon their registration, that is when Mr. Chandler, so the defendant's brother, came to learn of them. As I say, in January 2017, Mrs. Chandler's husband passes away. She remains in the property, and the defendant doesn't move in, I think, from the judgment, but certainly has a significant role in Mrs. Chandler's care and support, which she received at the home. Around about the same time, the defendant, it seems herself, rather than in the company of her mother, went to visit a solicitor where she openly admitted that she sought advice on the ownership of her mother's property. And during the course of that attendance, the defendant claimed or said to her solicitor that her mother wished for her to have the entire property in consideration for the care and support that she'd been provided, which of course does happen. You do tend to see where one sibling has taken on a large care and support role, that a parent might change their testamentary dispositions to reflect that and provide them perhaps with the property, especially if they've moved in. But it seems that Mrs. Chandler herself didn't go and seek that advice at the time. A few months later, so now we're into the end of 2017, Mrs. Chandler is admitted to hospital. And this is when her mental health appears to decline, because she is admitted with dementia and she's suffering from delirium. And there's also reference in the judgment to her having subsequently a diagnosis of, I believe, schizophrenia. So at that time, a DOLS, so deprivation of liberty safeguard, is put in place. For those of you who may not know what that is, where an individual is deprived of their liberty, if they are in, for example, a care home or a hospital, or even in their own home, and they lack the capacity to consent to that deprivation, then the state, so usually the local authority or the CCG, will have to have a deprivation of liberty safeguard, which is a procedural or administrative way of making the deprivation of liberty lawful. And so what we can take from the DOLS is that at that time, Mrs. Chandler lacked the capacity to consent to her deprivation in the hospital. We moved to 2018, and at the beginning of the year, the local authority carries out a further assessment of Mrs. Chandler, and the social worker concludes that Mrs. Chandler lacks the capacity to make decisions about her residence. So it appears that at that stage, from 2017 onwards, that Mrs. Chandler's dementia is such that she is quite impaired, because it seems that she was unable to make decisions of a relatively low level of complexity. So generally speaking, and in my experience, whilst capacity is decision and time specific, if an individual is unable to make basic decisions about where they are going to live, the chances are they probably will lack the capacity to carry out more sophisticated decisions, for example, a will, giving away their property and executing more sophisticated transactions. We move to June then, and what happens is on the 4th of June, and remember the defendant at this time is the registered attorney for her mother's property and affairs, goes to a solicitor, and she executes transfer in her capacity as property and affairs attorney of mum's property into her and mum's joint names. And she does that for no consideration. So she is essentially, as the attorney, giving the property from mum to herself and mum. A matter of 2 or 3 weeks later, the local authority again assessed Mrs. Chandler as lacking capacity to make most decisions. And while that's a fairly generic description, to me, it's suggesting, I'm sort of drawing large inference, that Mrs. Chandler by that stage was very, very impaired and probably would have been unable to make a decision about a gift of what appears to have been her most substantial asset within her estate. So brother then finds out about this, and he brings a claim on behalf of his mother's behalf. And what he seeks in this claim is twofold. The first is that he seeks a declaration that the transfer executed by his sister as attorney to herself and mum is void. And the second is that if it is a void transfer, that there's rectification of the register, and he relied then on Schedule 4 of the Land Registration Act 2002. He also, after issue of the proceedings, it seems obtained interim injunctive relief, and I suspect it was an order that prevented her from dealing with or disposing of the property whilst the proceedings were ongoing. So the issues were these in the case, and they were threefold. The first question for the court was whether the sister, so the defendant, in her capacity as LP, Property and Affairs LPA, had the authority to transfer that property to herself and mum. The second issue was if it were outside her power or her authority conferred by the LPA, was the transfer or the effect of the transfer void, or was it voidable? And I'll come in a moment to why that distinction was important in this particular case. And the final issue was, if the court was satisfied of those two, what, if any, relief should be granted? So the first issue, did the defendant have the authority to transfer the property? And it may come as no surprise to those of you who are familiar with powers of attorney and the Mental Capacity Act, that the court found that she did not have the authority to transfer the property. Now, remember, it was a gratuitous transfer for no consideration, so it was a gift. So essentially, what the defendant was doing was giving herself the property. And so that triggered Section 12 of the Mental Capacity Act. I set out that section in a little bit, but what it essentially does is it limits an attorney's power to make a gift. So under the 2005 Act, the attorney's power to make a gift is limited to charities, but not only charities, it's got to be shown that it would be a charity that the donor donated to historically, or would in all likelihood have donated to. So I tend to, if I'm dealing with statutory will applications, I'll tend to look through the bank statements to see if there's any evidence of that. Family members can also help with things of that nature too. Or it can be gifts to family members or individuals that P might have been expected to make gifts to, but they must be on customary occasions. So that's birthdays, Christmas, other religious holidays. And the final caveat is that they must not be unreasonable. The 2005 Act does not set out what is reasonable or what is unreasonable. And there is relatively limited guidance, I think, from the OPG on the level of gifting. You have to take it as it comes, really, and assess what's reasonable in the context of that estate. You might have somebody, for example, who has £5 million in an estate. And so making a gift of £500 on a birthday might be not unreasonable. Conversely, if you've got an individual who has an estate of £100,000 who's in receipt of benefits, then arguably something like £10, £20 might be a reasonable sum. So here the court held that, and this I think was a really interesting point actually, the court found that when looking at this first issue, so whether the defendant had the authority to execute this transfer or make this gift, the judge felt that Mrs. Chandler, her capacity to make the gift or to execute the gift, the transfer, was not relevant. And the reasoning that the judge gave was this: He said that the issue was whether the transfer was carried out by Mrs. Chandler's attorney and whether that was effective. It wasn't, as far as he was concerned, an issue of whether the transfer by Mrs. Chandler herself was effective. So, for instance, if Mrs. Chandler had actually signed the TR1, in this case, it was the attorney who signed the TR1. I have to say that's not a position I agree with. And I say that for this reason. The 2005 Act and Section 12 only becomes relevant if P, so the donor, lacks capacity to make that particular decision. Otherwise, the Court of Protection has no jurisdiction to entertain it. So here, it is relevant whether Mrs. Chandler had capacity or not to make this particular gift of her property. Because if she did have the capacity, and what we're looking at is that the daughter made a transaction without Mrs. Chandler's capacitous consent, if we're looking at that, then we can't have recourse to the 2005 Act because its jurisdiction isn't triggered. And therefore, the prohibition on gifting in Section 12 wouldn't have applied to the defendant. So I take a different view to the learned judge in that case. And my view is that it is relevant whether Mrs. Chandler or P had capacity to make the gift, because it helps us to decide, or it decides, whether we are looking at the Act and best interest, or Section 12 in this case, or whether it's a case of whether there was express authority to make that gift. So having found that there was no power to make that gift because the gift was a large amount, I think the value of the house is about £150,000. So clearly on any view, that is an unreasonable amount of money. And the gift wasn't authorised by the Court of Protection. So the defendant fell foul of Section 12. So the judge moved on to the next issue, and that was this: was the transfer void or voidable? And the judge acknowledged here that usually the distinction between the two is very much academic. And I agree with that. Sometimes it doesn't matter. It's sometimes important to consider what the effect of a void versus a voidable transaction might be. So void, it means it's void from the beginning. It never came into existence. Where if it's voidable, it is valid until the person affected by it takes a step to set it aside. So you may have someone who has entered into a voidable transaction, and for whatever reason, they decide, well, I don't want to take a step to set it aside because it suits me, or for whatever reason. That transaction would remain a valid one. So there is an important distinction there, but here it was particularly important because of the route by which Mr. Chandler, so the claimant, sought rectification of the register under the 2002 Act. So he sought rectification under paragraph 21A of Schedule 4. Go and have a look at it if you really want to. But what it does, I'll set it out there in summary, is it gives the court the power to alter the land register for the purposes of correcting a mistake. And in order to rely on that particular provision, so about correcting a mistake, the Court of Appeal held in NRAM, which I've set down there, 2018 case, that the entry in the register must have been made pursuant to a void, not a voidable disposition. So the practical effect of that would have been this: if the transfer by the attorney were voidable, the court wouldn't have the power to rectify under that particular provision. If, however, it were void, then it would have the power to do that. And the distinction is important here because if the register has been rectified for the purpose of mistake, then the affected party can seek an indemnity against land registry. So it can have an important consequence there. Here, the court found that the disposition was void, and that came as no surprise to me. And the judge set out there were three reasons why he came to that conclusion. The first was this: that the language of Section 12.1, he said, points strongly towards such a conclusion. And so at that point, it's probably helpful to consider the wording of section 12.1. And it says this: where a lasting power of attorney confers authority to make decisions about P's property and affairs, it does not authorise a donee, or if more than one, any of them, to dispose of the donor's property by making gifts, except to the extent permitted by section 2. And subsection 2 deals with the customary gifts, gifts on customary occasions, and also the charities. So what we have there quite clearly in section 12.1 is a prohibition on gifting, subject to the limited caveat, unless it is authorised by the Court of Protection. The second reason was this: that the prohibition in section 12 is not seeking to regulate the attorney's conduct, but has at its focus the gift itself. So it's not setting down standards by which the attorney must conduct itself. It's setting out very clearly that a gift, if it's made contrary to section 12, is not going to be an authorised one. And the final reason was this: that the conclusion that the transfer was void addresses, as the judge put it, the mischief which section 12 is designed to address. And at that point, the judge referred to a paper from the Law Commission before the 2005 Act was brought in, where it discussed the reasons why section 12 should have that prohibition. And the reasons given there were that if attorneys had unlimited authority, it might tempt an attorney to abuse their power. And secondly, that it would overall protect the donor's interests. I have to say, in practice, I don't personally find that the wording of section 12 necessarily stops an attorney who does think that way to actually make those gifts to themselves, unfortunately. So having found that the transfer was a void one, the final issue was, what's the relief that the court can give? And this is where the court considered paragraph 3.2 of Schedule 4. And the judge said that an order for rectification can only be made without the registered proprietor's consent. So in this case, this was the defendant and the defendant on behalf of mum, if they have by fraud or lack of care caused or substantially contributed to the mistake, or it would be for any other reason unjust for the alteration not to be made. So the court has the power to change and rectify the register without the registered proprietor's consent, but it has to fall into this condition, which is that there's fraud or lack of care which contributes to the mistake, or then there's the fallback position of any other reason that would make it unjust. At this stage, the defendant, I think, rather brazenly tried to argue that that shouldn't apply to her. She was in person, so didn't, it seemed, have the benefit of certainly representation at the hearing or advice, but she argued that when she went to see the solicitor in the June 18, that she wasn't aware, and she certainly wasn't advised by that solicitor, of the need to seek the Court of Protection's authority to make the gift. That argument was rejected by the court, quite rightly, because he said that notwithstanding her contention that she hadn't received that advice, she was still not acting with the appropriate care and skill that an attorney is expected to. It's often the case that attorneys will come to court when, I often find it happens like this: an attorney gets removed, then perhaps a panel deputy comes in, the panel deputy goes back through the bank statements, realises there's a whole host of potential misappropriation. And at that stage, the attorney will plead ignorance or that they weren't properly advised. But remember, an attorney is acting as a fiduciary, and so they have a duty or an obligation to seek advice in the way that a trustee has to, and a trustee will protect themselves by relying on counsel's advice, for instance, or solicitor advice when taking certain steps. So even though she wasn't given that express advice, the judge was saying, you didn't really take enough steps to ask for it. The second aspect that he relied on was that it was such a controversial and contentious step to take in the circumstances. It was all done secretly by the sounds of it. I always think that's a bit of a red flag if things are being done perhaps perniciously and with behind the scenes. And that given that the property was such a significant portion of Mum's estate, it was obvious that was likely to cause hostility or be met with opposition from other members of the family. So I think what the judge was very politely trying to say was that she knew exactly what she was doing, and perhaps she was trying to get away with it. So the judge rejected her argument on that and said that she should have taken steps to inform herself of the legal position, and the legal position would have been Section 12, and if you are contrary to Section 12, to get it authorised by the Court of Protection and to receive specific legal advice. So the outcome of this case was that the transfer was void, and that it was that because it was outside the attorney's authority, and that as a result of that, it was a mistake because it was a void transfer. So the court had the power to rectify the register and transfer the property back to Mum. So I just now summarise, because I'm just conscious I'm coming up to my half an hour, summarise my thoughts on what we can take from this case, and perhaps some points of principle or practical points. It's probably a better way of dealing with it. So the first is that it's a really good reminder, and sometimes this can be forgotten, to check what the attorney or deputy's authority. I was quite surprised, actually, when I saw that the daughter had been to a firm of solicitors for them to prepare and act on her behalf in the transfer. And I've seen it myself in practice, where I've been asked to advise on the consequences of these kind of matters, where an attorney has been to a solicitor to transfer property and it hasn't been picked up that the attorney just can't do that. And so it's a sort of statutory reminder that if you are, for example, dealing as a conveyancer and perhaps you come across more non-contentious matters, to be alive to this issue, especially because conveyancing is such high risk, and I see routinely matters like this cropping up. But also, it's not just attorneys that you need to be mindful of, because an LPH has a really broad power conferred upon an attorney. Deputies also be very mindful of their authority, particularly with the deputy, because the deputy order, whilst it's broad, the position of the Court of Protection at the moment is that unless it's in the order, the deputy doesn't have the order to do it. So I always err on the side of caution and look for an express provision for the deputy to do that particular act. So if you are dealing in a conveyance or some form of instruction like this, make sure you check the deputy order to check that what you're being asked to advise on and do, your client's actually able to do. And I think the second point is to ascertain the donor's capacity to make the particular decision. I've set out where my view parts or departs from the judge's analysis. I do think it's important when you have a scenario like this to ascertain whether the donor has the capacity or lacks the capacity to transfer their property, because not only does it lead to a whole host of issues, for example, deprivation of assets if the individual goes into a care home and things of that nature, but it does dictate whether we're in the Mental Capacity Act or not. If the donor does lack the capacity to make that gift, then we're under Section 12. We need to make an application to the Court of Protection. Whereas if we are not under the COP's protective jurisdiction, then need to be checking expressly with the donor that they're okay to do that. I sometimes get instructions where the attorney is conducting the litigation on behalf of the donor, and it's just been assumed that because this is a registered attorney, that the donor's okay with the attorney doing that litigation, and they may not be. They may not be authorised to do that if they retain capacity. So it is really essential, and I often think this gets forgotten about, in that there seems to be sometimes a presumption that if there's a registered LPA, the attorney can do what they want. I think that is probably an unwise approach, especially in conveyancing, because of the high risk of it. So I would always check that what the position is. And if they do, if you have got concerns about capacity, of course, get it assessed. The third point I think that is useful from this case, that sometimes, it doesn't always come across our desk, whether it's a void or voidable disposition or transaction. And it's an important aspect to be aware of, because I advise on this really frequently about what's the effect of a particular transaction if the person lacked capacity or retained it. And I've sort of summarised what I think, or what my views are, because there are certainly conflicting authorities on it. But generally, I take the view that if it's a voluntary disposition, so somebody making a will, obviously, or a gift, so deed of gift, certain deeds, so if you were making a sort of old school power of attorney rather than a lasting power of attorney, or something like a deed of appointment, because that's a voluntary disposition rather than having any consideration for it, then, as I say there, if the individual lack capacity to do that act, it's probably going to be void rather than voidable. And the consequence of a void transaction is it affects innocent parties, and that's the key aspect of it. Whereas with voidable transactions, it doesn't necessarily do that. And I'll come to why that is in a moment. So the other side of the coin is if they're, I call them transactions for consideration. So in any contract, basically, house purchase, something, if you're entering to a deed of maybe a loan, and so you're entering to a charge or something like that, so something where there's consideration, then that's, if the individual who was entering into that lack capacity, then that's probably going to be voidable rather than void. And you'll recall earlier, set out the differences between. So if you had a transaction that were prima facie unvoidable, then the attorney as litigation friend or a deputy litigation friend would have to take a step to actually set that aside. So you'd actually have to get a court order to set that aside unless it could be agreed. And the final point there is that if it is the latter, so if we are talking about transactions with consideration, then you need to just have on your radar this case of Imperial Loan Company, because what it essentially says is that the other party to the transaction or the contract needs to know that the person lacks capacity, or they should have known that the other person lacked capacity to do what they're being asked to do. So that's fact specific, of course. So it's actual knowledge or constructive knowledge. And if you can prove that, then that renders that particular transaction liable to be set aside. That in itself is quite a complicated area. It probably justifies a seminar in its own right. But I thought that this case certainly flagged that up as an issue that would be certainly useful for people practicing in these areas to be mindful of. And the final point is this, is if you are advising attorneys or deputies, to advise them and make them aware that they need to make these applications for retrospective or prospective authority. Ideally, it should always be prospective. You're much better, you'll perhaps have more, not favourable treatment, but it will just look better if you go to the court before the deed is done. In my experience, they're treated more favourably than doing things retrospectively. And I think it's important to ensure that that's done if we are in the COPS jurisdiction before P passes away. Because if, for example, they pass away and the act of the attorney or the deputy isn't authorised, then it perhaps becomes very difficult, maybe impossible, to have it retrospectively approved, because that retrospective approval, as I see it, rests with the Court of Protection. And once P passes away, the jurisdiction of the COP also goes. So it does raise a question mark, is if P passes away and you haven't had those transactions authorised, how can you do that post-death? So it's certainly something to be raising with attorneys. And that's why I say doing it prospectively is much more preferable. And the final point is, if Dee had thought about that, or if she had been advised, would she have succeeded in any application? I personally think the chances are very slim, because she was it seems to me from the judgment acting entirely for her own financial interest. We don't have a great deal of information about the value of Mrs. Chandler's estate, but for a court of protection judge to authorise a gift of somebody's property to their child or to anybody, they would have to be have an estate of a significant estate and be of significant means, because when the court looks at that kind of application, so a gifting application, they will look at the size of the estate, the care needs, how their care needs are funded, inheritance tax, deprivation of assets, all these sorts of things. And here, it did cross my mind that one of the reasons the daughter did this was in an attempt to avoid payment of care home fees, because in the judgment there's reference to when mum is coming out of the hospital, the daughter doesn't want her to go home, and it's clear she had quite extensive care needs because she does ultimately go into a care home. And sometimes I tend to find people can make that suggestion because they know that if mum goes home, the value of the property can't be taken into account for the purpose of care home fees. So I did wonder if that was ultimately her misguided motivation in it. So I think the chances with this particular case, the defendant wouldn't have got it retrospectively authorised. And the consequence of that would have been not that the court of protection can order her to pay it back. And of course, with attorneys, there aren't any bonds. So the only recourse then is to do what the brother did, which was to bring these sorts of proceedings. And it's important to be aware of bringing these sorts of proceedings, because if you are acting for a claimant like this, or you're a deputy, for instance, acting for a P like Mrs. Chandler, then if you don't take steps, the local authority might have something to say about that if they want to take the house into account for care home fees. And so it has to be a decision that's really thought about where the proceedings are brought, because you don't want to be on the receiving end of an argument for the local authority that there's been a deprivation of assets. So that brings me to the end. Oh, I've only gone over by 10 minutes. I hope that was useful. As I say, there's my email address. If you have any questions, then please do feel free to get in touch. And it just leaves me to say, from myself and Kings, thanks very much for joining, and good afternoon.